Good morning, Carla Hartley here. I am continuing my discussion regarding the factors a court must consider when a request for the child to move away with a parent has been brought before the court. Okay, today we're discussing factor 4, and again, this is my numerical sequence. I don't think you're going to see factor 4 anywhere if you do a Google search other than here. So, factor 4, the distance of the move. You've got to be thinking, well, yeah, the court has to consider the distance. This is a no-brainer. Nothing is a no-brainer in the law, and I think the corollary for that is nothing is a slam dunk, particularly with regard to move-aways. So, let's start. The distance of the move, we're going to divide it into 4 different categories, all right? Within the county, within the state, within the United States, and then outside of the United States. So, within the county, most often is not a huge consideration, but it can be depending on the size and population density of your county. So, let's just say you're planning to move, you've got an order that says that if you move more than 15 miles, you've got to inform the other party and either get their consent or get an order from the court permitting the move. So, all right, within 15 miles, great, you're going to move 25 miles. Well, if you're moving 25 miles in, for instance, eastern Kentucky, where there's literally no traffic, you've created a half-hour drive. Well, depending on which part of eastern Kentucky you're in. Let's assume you're along I-64. So you hop on I-64, you go up to the next exit or two, and then you're right there. It's not a tremendous inconvenience, and it shouldn't be a tremendous problem to get your child back and forth to school, to all that other stuff. We're not looking, in this case, at a huge disruption in the child's life. So within the county, just up the road, not a big deal, okay? Now, if you're moving out of the county but within the state, a lot of states have crafted their orders so that if you're moving within the state, you pretty much just give notice to the other side, and then they have a period of time to object by filing a motion with the court. And if that motion isn't filed, they can move. This is not all states. Do not rely on what I am saying here for your legal action. Get an attorney. I am so generalizing in this video. I'm trying to give you a broad overview. These are not the nitty-gritties. All right, so you're moving, say, 2 counties away. This is going to create a problem because the court has to consider how are we going to keep the child's, we discussed this before, the child's interest in the stable and continuous custodial arrangement in place. So if the non-custodial parent has, for instance, 2 weekends a month and on the off week a midweek dinner visit, that's an amount of time that the court can probably adjust to ensure that the dad or the mom, who is not the moving party, is going to be able to continue to have that same amount of time, just configured differently. So let's say they have 40 hours every 2 weeks. That's going to be something that the court needs to look at and say, okay, how do I arrange this so that I can have 80 hours a month for this kid, or average 80 hours a month by adjusting what's happening over the breaks in the summers. And keep in mind, this is one factor. We have the best interests of the children factor. We have the relationship of the child with the parent. All of this goes together. The court has to consider all of these. I'm discussing this one factor sort of in a vacuum. So keep in mind, this one factor is not the controlling factor. There really aren't very many controlling factors. And I would never be so unwise as to tell you which ones I would regard as controlling, because it varies from case to case, because the facts vary from case to case. All right, so we've dealt with moving within the state. You're going to probably have to go before the court, and the court's going to have to figure out, how do I make this work for these people, for these children primarily? Now, the children may end up, and the court's going to look at this, other factors are considered, the court decides to flip custody for some reason because, as we discussed in prior videos, detriment has been proven, so on and so forth. Then the court's going to say, okay, if the custodial parent moved there, we're going to keep the kid here maybe. We're going to keep the child in school with all these relationships. I still have to find a way to make sure that the now new non-custodial parent is getting plenty of time. So don't assume that just because you're moving within the state, this is going to be a piece of cake. I also want to add here, some states are very large. If you're moving within the state of California, it is no small undertaking if you're going to go from Southern California to Northern California. That's the distance of 3 states back east. All right, so we've moved within the state. We've discussed within the state. We've discussed within the county. Now we're going to talk about if you're moving out of the state, but within the United States. Within the United States, all the same laws still apply. So we're still looking at distance and how to create a custodial timeshare where the child has frequent and continuing contact with both parents. That is a legal standard, by the way, and it's also a psychological standard that is shared pretty much in that profession among child custody and child psychology experts. Frequent and continuing contact with a parent, with a non-abusive parent, is in the best interest of the child. So where you're moving becomes important. If you are trying to go from California to Texas in the Dallas-Fort Worth area, there's a flight. For instance, if you're going from Ventura, California to Dallas, Texas, there's a flight from Santa Barbara, which is a half hour from here, into Dallas-Fort Worth that is 3 hours. It's a direct flight. It's easy to do, and it's not going to be hugely disruptive. It means the court can get the child back and forth with a minimum of grief and a minimum of time and a minimum of exhaustion for that poor child. On the other hand, if you're trying to go from here to Des Moines, Iowa, that is a grueling affair with switching flights, the drive at the end of the flight. If you choose to go out of LAX to save yourself a leg, then you're going to be adding really a lot of time to the front of it by driving to LAX. So the court has to look at this because the best interests of the child don't include sending the child off to another state on alternating weekends where the child spends the whole time in the airplane. That just exhausts the child and does nothing to increase the relationship or to improve the relationship of the child and the non-custodial parent. So distance is a factor. Now, if your ex or your opposing party or you want to take the child out of the country, we're looking at Hague Convention concerns. Hague Convention is a big deal. If we're looking at taking a child to a country that is a Hague Convention signatory, and by Hague Convention I mean a nation that has signed on to that portion of the Hague Convention treaties that deals with child custody jurisdiction and enforcement issues. A lot of nations have not signed off on this convention. So if you're going to be taking a child to a non-Hague Convention country, generally we are going to want to oppose that here in the States. But that's not all, because there are a number of Hague Convention countries who are longtime allies strategically of the United States who do not assist us in enforcing our orders with regard to child custody and visitation. So if it's going to be one of those countries, you're going to want to have expert testimony so the court can go, it's one of those. Probably the court knows, but the court, remember, needs to have evidence, and you've got to have evidence in your case. So the court's orders should not be overturned on appeal. You want to do everything right. Move-aways are appealable. So this is one of the factors the court has to consider. And you need to take a look at it and think about whether what you want to do is feasible. And you need to do this by talking to counsel. I cannot be more clear on this. Move-aways require, or they should require, at least a consultation with competent counsel. All right, that's all I have for you on the distance of the move, or that's all that I'm willing to share, and I'm already over my little 6-minute window. So I don't know how to get this any shorter. I've tried a couple times. I hope it's been helpful. Call an attorney if you're looking at a move, or if the other parent is trying to take the child on any kind of significant move. It's important.